Hiya. Thank you so much for being here on a Thursday afternoon in the latter part of our spring semester for this very last minute, very important discussion. We are here today to talk about the leaked draft of the Dobbs case, a Supreme Court case that tests the constitutionality of a 15-week abortion ban in the state of Mississippi. As you may be aware, if you're here at this panel today, this leaked draft decision outlines the court's overturning of Roe v. Wade, the 1973 case that legalized abortion prior to the third trimester of pregnancy at the federal level. So here we are, nearly 50 years after abortion was legalized, facing an ever clearer reality that we are about to lose the right to abortion. As far as I know, the first time in our nation's history where a right that was once considered fundamental is about to be taken away. I know there's a lot of confusion about this and a lot of fear about what this will mean for us, that a right that my mother and my grandmother relied on is not a right that I will be able to rely on for the rest of my reproductive life. So that's why I organized this very last minute panel with the generous assistance of the SJSU Human Rights Institute. Thank you all so much. We at SJSU are so lucky to be joined by these internationally recognized experts in the law and politics of reproduction. So first, let me introduce myself. My name is Grace Howard. I'm an assistant professor of justice studies here at SJSU. Before I became an academic, I worked as a birth doula, assisting and supporting people through childbirth. I also worked at an abortion clinic, providing clinic security, counseling, and hand-holding for patients. My research expertise is in the law and politics of reproduction with an emphasis in what we call the criminalization of pregnancy, or the criminal prosecution of people for crimes against their own pregnancies, something we can certainly expect more of in the coming years. To date, at least 1,600 pregnant people in the United States have been arrested and charged with crimes against their own pregnancies, and most of those arrests have happened in the last decade. For things like disobeying doctors' orders, for having stillbirths and miscarriages, for terminating their own pregnancies, for a single positive non-consensual drug test, for surviving suicide. And this is with the protections of Roe v. Wade. I'm currently writing a book, The Pregnancy Police, which is forthcoming with University of California Press, that explores this issue. I'm also somebody who had an abortion. I'm thankful for my abortion. I loved my abortion. Without my abortion, I probably wouldn't be a first-generation college graduate. I probably wouldn't have gone to graduate school. I probably wouldn't have earned my PhD, and I probably wouldn't be on this webinar talking to you about abortion. Without my abortion, I might not even be alive right now. And I'm not alone. 1 in 3 women in the United States will have an abortion in their lifetime. And so now we are facing this stark reality where abortion could possibly become legal throughout the United States. I think it's more important than ever that we have honest conversations about our sexual and reproductive lives, about our personhood, and about what we will do in a landscape without Roe v. Wade. Joining us in this conversation, we are so privileged to have Catherine Colbert, a public interest attorney, journalist, and entrepreneurial leader. Colbert has been recognized by the National Law Journal as one of the 100 most influential lawyers in America. In 1992, Colbert made her second appearance before the U.S. Supreme Court, arguing Planned Parenthood versus Casey. This landmark case has been widely credited with saving Roe v. Wade with what was called one of the most audacious litigation strategies in Supreme Court history. From 1992 to 1997, Colbert directed domestic litigation and public policy programs for the Center for Reproductive Rights, which she co-founded and served as its first vice president. She's also served as the state coordinating counsel of the National ACLU's Reproductive Freedom Project and as a staff attorney with both the Women's Law Project and Community Legal Services in Philadelphia. Kimberly Mutcherson, who mentored me a little bit when I was a grad student, is co-dean and professor of law at Rutgers Law School in Camden. She's the first woman, the first Black person, and the first member of the LGBTQ community to have this role at Rutgers Law. Dean Mutcherson is a reproductive justice scholar whose work focuses on assisted reproduction and abortion. Cambridge University Press released her edited volume, Feminist Judgments, Reproductive Justice Rewritten in 2020. In 2021, Dean Mutcherson received the Association of American Law Schools Inaugural Impact Award as a co-founder of the Law Deans Anti-Racist Clearinghouse Project. She received the Center for Reproductive Rights Innovation in Scholarship Award in 2013, a Chancellor's Teaching Excellence Award in 2011, and the Women's Law Caucus Faculty Appreciation Award in 2011 and 2014. And that's my foster cat telling us what she thinks about all this. Dean Mutcherson has been a senior fellow and sabbatical visitor at the Center for Gender and Sexuality Law at Columbia Law School and a visiting scholar at the Center for Bioethics at the University of Pennsylvania. She received her BA from the University of Pennsylvania and her JD from Columbia Law School. Prior to joining the faculty at Rutgers, Dean Mutcherson was a consulting attorney for the Center for Reproductive Law and Policy, now the Center for Reproductive Rights, and a staff attorney at the HIV Law Project. She received her BA from the University of Pennsylvania and her JD from Columbia Law School. And finally, last but not least, we have Erin Hyde-Forsyth, an associate professor of women's studies and political science. Erin Hyde-Forsyth received a PhD in political science with a focus on women in politics from Rutgers University. Me too. Her work examines the intersections of gender, political science, and bioethics. Employing mixed quantitative and qualitative methods, she studies US state legislation and policymaking about assisted reproductive technologies. She has published on assisted reproductive technologies, feminist bioethics, and social policy, including her recent book, Between Families and Frankenstein, which is amazing if you're interested in reproductive technologies. Her areas of specialization include science, medicine, and health, reproduction and the body, American state politics and policy, interest groups, and representation. From 2012 to 2013, she was a grant-funded faculty research associate at the Center for Genetic Research, Ethics, and Law at Case Western Reserve University. She joined the Department of Women's Studies and Political Science as an assistant professor in August 2013. So each of our esteemed and badass panelists will talk for about 10 to 15 minutes, and then we will use the rest of our time for a Q&A. Take note, if you look at your Zoom screen, if you look at the bottom panel, you'll see a Q&A button. If you have a question, you can type it in there, and we'll see if we can get around to it at the final portion. And so with that, we will go ahead and start with Catherine Colbert.
Thanks, Grace. It's a pleasure to be here, and thank you all for tuning in. I know it's difficult on a Thursday afternoon to hang out on Zoom instead of having fun, but it's a really important time in our nation, and it's a really important time for all of you to become active in making change in our world. So I want to do a couple of things. First, I want to talk a little bit about the draft opinion by Justice Alito, what this means both for abortion rights and for a range of other rights that are dependent on the 14th Amendment's Liberty Clause, and then a few thoughts about what I think we all need to do. But first and foremost, let me just say, I have been predicting the end of Roe for a very long time, since the day after Donald Trump was elected president of the United States. So this decision does not surprise me. It is what we expected to happen. And in fact, we wrote a book that came out a year and a half ago predicting this very thing. But two things did surprise me. First and foremost, it surprised me that the decision is written in such a broad way. It doesn't just undermine Roe or Casey. It doesn't just uphold this particular statute, which would have overruled Casey and Roe. It goes much, much further and does a couple of things. First and foremost, it abandons the doctrine of stare decisis as we have known it. Planned Parenthood versus Casey is known as a case that upheld Roe versus Wade, that meant that legal abortion would be permitted in all 50 states up until viability. It gave much greater latitude to states to restrict abortion rights, and that has had incredible repercussions, particularly for the most disempowered people in our society, for poor women, for young women, for disabled women, for women in rural areas, and too often Black and brown women who are discriminated against in the healthcare system. We know Casey hasn't been all good. But the reality is in 1992, the court permitted legal abortion in every state in this country. And so while Casey wasn't all good, and for a lot of women was produced serious, serious hurdles, it also meant that other women, about 600,000 women each year, have been able to obtain legal abortions. When, and I'm going to say when as opposed to if, when Justice Alito's opinion becomes law sometime before the end of June, and let me just say, my aside here is, it's when to me because I don't see this five-person majority shifting at all. But when this opinion becomes law, we will see at least 25 or 26 states ban abortion in some form. And there may be variations, some say 5 weeks, some say 6 weeks, some say from, the moment of conception, some say have exceptions for life or rape and incest. It doesn't matter. In reality, women in all 25 states will be unable to obtain abortion services. Why? Because even if there's a 5-week ban as opposed to from conception, the business of providing abortions, the independent providers who have been out there providing great services for so many years, will be unable to continue to practice law. The risks are just, or practice medicine. The risks are just too high. So what does that mean? We're probably going to see abortion banned from Georgia all the way across the Southwest to Texas, from the Canadian border south to the Mexican border down through the mountain states. In states like yours, California, Oregon, and Washington on the West Coast, the East Coast north of Pennsylvania, New York, and further north, those states will continue to provide services. A few in the middle of the country like Illinois, maybe Kansas, will continue to provide services. But the reality is all of those women, probably close to 350 to 400,000 women facing unintended pregnancies, will have to do one of two things. One is travel to get an abortion, or find access to the abortion pill, which they will have to get clandestinely because it will be illegal to get it in their state. And that may mean traveling, that may mean internet services, it may mean getting it from a friend who lives in a state like California. But it does mean susceptibility to criminal prosecution. And I'm going to let Grace talk a lot about that. But the reality is women will be prosecuted for trying to self-induce abortions as a result of these kinds of bans. The other thing, and I think this to me is perhaps the most disturbing, is the notion of stare decisis as set forth in Casey has been abandoned. And this court has basically said that the votes of 5 people who were not happy with the original decision, who didn't like it, who thought it was wrongly decided, have the power to take away a right that millions of women have relied upon for now almost 5 decades. And that to me, in the politics of the court and the politics of this issue, is extraordinarily scary. And it basically undermines the rule of law as we know it. Now, I think the big question everybody's asking is, can this court do that to other rights in addition to abortion? And my answer is yes. A lot will depend on the focus of the right wing, what kinds of restrictions they want to impose, and which cases then get to the high court. And for example, in my view, contraception may be the next point of attack. Gay marriage may be the next point of attack, because those are places which we've already seen the right try to undermine. Today, before this becomes law, states are considering statutes that ban certain forms of contraception, and particularly the morning after pill, or the IUD or the pill, which they believe to be an abortifacient because the drugs work, or the IUD work, post-conception. their view is life begins when the egg and the sperm join, even before there's a pregnancy, which happens at implantation. Anything that interferes with implantation, in their view, is an abortion. And they've written these laws very, very broadly to affect contraception. So I'm going to stop there because I know the rest of this panel is really fabulous and you all have many, many questions. But first, I want to say two things, and that is, we need your help to win back the rights that we are losing, that will affect your reproductive rights for your entire reproductive years and those of your peers. Those rights are not going to miraculously come back. The only way we will get them back is to work politically to make a difference. And that means focusing lots and lots of time, effort, grit, perseverance to flip legislatures in all 50 states and to ensure that there is a filibuster-proof Senate and control of the House in Democratic hands. I'm going to talk really hard politics here, which is the Republican Party is anti-abortion. The Democratic Party is not. This no longer, in my day, this used to break down that there were anti-abortion Democrats and pro-choice Republicans. Not anymore. We are talking about red and blue. So the only way to win is to keep blue states blue, to flip purple states to blue, and to ensure that red states turn blue as well. And you in California can make a difference. How? By volunteering in those campaigns all across the country. You can make phone calls, you can do text, you can, I was hoping that you could be part of a reproductive freedom summer, similar to what happened in the civil rights era, when college students across the country began to mobilize and work. So come to Pennsylvania, come to Kansas, come to Illinois, come to, all kinds of, go to Texas, go to Georgia, and work in campaigns that will make a difference, because your bodies are on the line, and we need your bodies to win those rights back for all of us. Thanks.
Thank you so much for that, Kitty. Next up, we have Kimberly Mutcherson.
Thank you. So I'm both a Virgo and just generally type A. So I am actually timing myself so that I don't go on for too long, because I'm also a law professor who is not in love with the sound of my own voice. I actually like to have conversations with people. So I want to make sure that we have time to do that. So I'm going to do a couple of things. One is I want to expand our conversation a little bit by making sure everybody's on board with what we mean by reproductive justice as opposed to reproductive rights. And then I want to expand more on what Kitty started to talk about a little bit, which was what would overrule, or what will, because I'm in the same camp as you, Kitty. This is a when, not an if. What will that mean for other rights? And then hopefully set things up a little bit for Erin to talk about some of the personhood implications here. And I'm going to do all of that in 14 minutes. So reproductive justice. So oftentimes you will hear reproductive rights and reproductive justice used interchangeably. I am a reproductive justice scholar, and I think it's really important for folks to understand where that comes from. So reproductive justice is a movement. We use it a lot in theory now, but it is a movement that was started by Black women in the mid-90s. These were folks who were activists and organizers in their communities, and who became very frustrated by their feeling and their reality that a lot of mainstream women's rights organizations simply were not attuned to the kinds of issues that were imperative for Black women in particular, but for women of color in general. And so the idea was to start a movement that was more broad-based, right? That wouldn't just drill down on abortion, but would really think about the range of issues that are important in the lives of Black women and women in general, and at this point, anybody with a uterus. So reproductive justice basically has three tenets. One is the human right to have a child, if that's what you want to do. Two is the right to not have a child. And three is the right to raise your child in safe and healthy environments. So if you just think about that, it's very clear how expansive reproductive justice is, right? So it's about obviously access to abortion and contraception, but it's also about environmental justice. It's about, stopping the school to prison pipeline. It's about pregnancy discrimination, right? It's a whole range of it. It's about police violence, right? A whole range of different issues. So when I think about what we're talking about here, I really think not just about what it means for abortion rights, but those other sorts of dominoes that are going to fall. So now let me talk about the rights issue. And I know I'm not talking to a group of law students and lawyers, so I want to make sure that I am breaking this down as much as possible. So a couple of things that were in the draft Alito opinion that have been talked about a lot in the news. One is his very early assertion that abortion doesn't appear in the Constitution. So that in of itself makes the idea of a right to abortion specious. And then two, the way that he walks through what it means for us to have a fundamental right. So let me start with the enumerated rights question, which is actually a very quick one to dispense with. The word woman doesn't appear in our Constitution. Privacy doesn't appear in our Constitution. The internet doesn't appear in our Constitution, right? So the idea that we would limit rights based on what a bunch of people who couldn't even imagine what the world looks like now thought about what our rights should be is a little foolish. And of course, we have a whole amendment that says rights that don't appear here are left to the states, right? So it's clear that our Constitution is not meant to be static. That's all I'm going to say about that because it's just such foolishness. The fundamental rights. So the court has over many, many, many years articulated some rights that they think are so important that they call them fundamental. And if a state wants to infringe on those particular rights, those infringements, right? So those laws are going to be subject to what's called the highest level of scrutiny. In other words, it's going to be much more likely that the US Supreme Court will find those to be unconstitutional, right? So you have to be doing a really good job of creating your statute if you're going to infringe on a fundamental right. And the test that the Supreme Court has created for fundamental rights is whether it is a right that is deeply rooted in the nation's history and traditions. So I will go back to what I said about enumerated rights, which is, the four of us who were sitting on this panel did not have rights in the beginning of this nation for a variety of different reasons. Pretty much if you were not a white man who owned land, you didn't have rights in this country for a variety of reasons. So starting from that beginning is also deeply, deeply problematic. And as Kitty said, when the court decided Roe versus Wade, they did decide that being able to have an abortion was a fundamental right. And the court has been sort of moving away from that for many, many years, and finally is at the point where they're just done with it in general. So that is all has to do with abortion. But there are other rights that have been read into the Constitution. And this is another part of the conversation that's been happening in the world. There are other rights that have been read into the Constitution that don't appear as enumerated rights and arguably could not be thought of as being deeply rooted in the nation's history in tradition. So I'll just give you a couple of examples of that. Marriage doesn't appear in the Constitution. The Supreme Court has determined it to be a fundamental right. And then finally, in the Obergefell case, they extended marriage to same-sex couples. In the 1960s, the court said that you couldn't ban people from getting married because of race. So we've expanded what it means to have a fundamental right to marriage. But if the idea that we cannot protect rights that are not rooted in the nation's history and traditions, well, certainly cross-racial marriage, or to be more specific, right? Because what states really were banning was white people marrying anybody who wasn't white, right? I could have married anybody I wanted to as long as they weren't white, right? Because it was all about white supremacy. So certainly not deeply rooted in our nation's history and traditions. Obviously, marriage equality is not rooted in our nation's history and traditions. Another fundamental right that the court has articulated is the fundamental right to the care, custody, and control of your minor children. That does not appear anywhere in the Constitution. And that has been a really, really long path of how the court has thought about that fundamental right. But that's the reason why, for instance, you can keep custody of your kids. It's the reason why you get to make medical decisions for your children. It's the reason why you get to decide where your children go to school. So if that is implicated in this context, and you think about things like the bans on gender affirming care that are taking place in some parts of our country, if there is no fundamental right to the care, custody, and control of your minor children, those kinds of bans stand on much firmer footing than they should. And then the last thing that I want to talk about is the personhood implications. And that's the setup. I think that's the good setup that I'm going to give you. So the personhood implications. So another piece of what Alito says or writes in his opinion is that, abortion is just totally different because none of the other rights that I have just talked about that are also unenumerated in the Constitution involve taking fetal life. And so, we don't have to worry about anything else because it's only about abortion. And if you believe that that's where this is going to stop, then I have an absolutely gorgeous bridge in Brooklyn for sale that I would like to sell to you. So, what does that mean in terms of how this court is going to articulate the state interest in protecting fetal life and not just fetal life? Because if what we're talking about is expanding the definition of pregnancy and abortion, then it's also talking about things like frozen embryos, right? And what kinds of rights the state might have to protect an embryo, to protect a fetus, and making those rights comparable to what it means to protect a 5-year-old, right? And if you're thinking of it along that continuum and you're feeling really scared about that, good, right? Because what that means is incredibly, incredibly expansive for how states get to intervene in the lives of people who are pregnant, in the lives of people who are seeking pregnancy, and in the lives of people who are parents. So I'm gonna leave it there and let our next speaker go.
So thanks so much, Kimberly. That was an amazing setup from one Virgo to another. Thank you very much. So I'm going to take a slightly different tact. As somebody who studies state politics and state sort of legislative activity, that was just a really nice setup for me to talk a little bit about how state activity around abortion and around personhood more broadly. And I'm going to take that very, very broadly to not only include how we might think of the fetus and the embryo, but also the personhood of people who are older as well, has been a much longer project of the states, almost knowing that the possibility, as Kitty was saying, that Roe would be overturned. We know this very obviously through things like trigger laws, but I would argue that there's also a lot of legislation that has kind of been in the works that might tell us or give us some clues at least as to what's going on. For those that don't keep track at home as to what all 50 states are doing all the time, at least 531 anti-abortion restrictions have been introduced in 40 states this year alone. That's over 500 in 40 states. We know that there has been a massive uptick in anti-abortion legislation at the state level since 2010. It's much older than that, but we've seen a rapid increase since that point. With this, I also really want to be careful to tie this to other laws that we might think of and other sorts of legislation that I believe are deeply tied to abortion. And in this, I think are deeply tied to ideas of autonomy over one's body, how you can make decisions about your reproductive life. Sort of as Kimberly said, the right to have a child, the right to not have a child, and the right to raise children in a way that's healthy and safe. If we think about that really broadly, that includes everything from gender affirming care, particularly for trans adolescents, trans children, all the way to trying to regulate public life for transgender folks, as well as to sort of my area of expertise, which is around infertility and assisted reproductive technologies. So I'll start here by just saying that the state has a real interest and has demonstrated a real interest in trying to regulate what bodies are acceptable and what bodies are not acceptable, and what those bodies should or should not be doing. As we know, there's been literally hundreds of anti-trans pieces of legislation regulating everything from getting sort of support for social transition, all the way to medical transition, all the way to social activities, right? And the ability of a child to grow up in the way they would like to in their families. I'm going to move, though, that while that is about bodily autonomy, and I believe is sort of around and in under this umbrella of personhood, I'll talk a little bit more specifically about personhood statutes. So personhood statutes are pretty popular. They've been attempted to be passed at the state level for a long time. And generally what they are bills that try to say that life begins at conception, at fertilization, where the sperm meets the egg. Largely, these personhood statutes have grown since the early 90s, and in general, they haven't been that successful. However, they definitely point to the ways that I believe an overturning of Roe, the Dobbs decision, and Casey help us maybe understand what's in store for other areas. So in terms of assisted reproductive technologies, it's a really long name for something that you might know called in vitro fertilization, where the egg and the sperm are brought together outside of the body for the purposes of making a baby in general. While IVF is known as like a family formation technology, it's actually tightly tied to abortion in some really, really important ways. So if you believe that life begins at fertilization, then a lot of the parts of IVF are going to be problematic for you. You're creating embryos outside of the body. Those embryos either have to be implanted in a person to create a pregnancy, or they have to be stored. If to store embryos, you have to pay a lot of money, and you have to pay it every month to actually store those embryos as long as they're going to be stored. And if you don't want to use them or you don't want to store them anymore, you need to discard them. There's also kind of a small subset of things that happen where clinics may unintentionally destroy embryos as well. That can be a loss of refrigeration, some kind of technical errors. So in general, what we've seen in the last couple of years, which I find really interesting, there's an example, I believe, in Alabama of this, where there's been abortion bans put in place that have explicit IVF exemptions, meaning that abortion is sort of banned with the definition that life begins at fertilization, with the explicit exception of fertilization that happens outside of the body. So to quote Republican State Senator Clyde Chambliss, who actually co-sponsored a bill that later became law in Alabama, which banned abortion, he said, quote, "The egg in the lab doesn't apply. It's not in a woman and she is not pregnant." So we can see here how potentially, while I would argue that personhood bills and an overturning of this decision obviously may target the fertility industry, and how the bill in Louisiana is written is a really great example of this. We see that the regulation of reproductive technologies at the state level is very precise. I've done some research on how Republicans and Democrats at the state level are interested in regulating things like egg donation. And what I find is that Republicans and Democrats are interested in regulating different things. So Republicans are really interested in regulating the behavior of egg donors. They're also really interested in regulating the disposition or what happens to an embryo after you make one. Democrats, on the other hand, are more interested in things like parental rights or access through sort of insurance plans to infertility care. I've also just published some recent work that looks at attitudes about IVF. And in general, most people do not have a moral problem with in vitro fertilization, and that exists across racial and ethnic groups. So how does this play out? Just to kind of sum up my comments here, in terms of how Roe might play out in the infertility industry. Again, I'd like to step back and tie this to other issues in the fact that the state is interested in regulating the bodily autonomy of people. How they're going to do that and who is seen as vulnerable will be targeted in different ways, right? So in terms of the fertility industry, we might see more emphasis on things like embryo adoption. This is the literal mandated adoption of embryos that are created in a lab. This became very popular in the early 2000s. George Bush very publicly took a picture with a bunch of babies that had been adopted through embryo donation. I believe there's going to be a lot more limits on disposition. So you create an embryo, what's going to happen to it? Even though we see IVF exemptions, I believe that there will be increasing attention to what happens to embryos that folks don't want to store anymore or cannot use. And finally, and I think very importantly, parental rights. And this goes back to some of Kimberly's comments about the relationship of parents and children, which I think is something that is already happening and we're already seeing with a lot of regulation of trans children and trans adolescents. But I do think this is going to become an issue for donors, that there is going to be a tension between the biological parents of a child created through assisted reproductive technologies and the intended parents. We've seen a lot of discourse around adoption. I think we should pay a lot of attention to what's going on with that discourse, which I wish I could get into, which is very interesting, but I will leave it at that for today.
Amazing. Thank you so much, Erin. And I guess it's my turn. Just to remind you though, for those of you in the audience, if you have questions, next up we're doing our Q&A. So you can ask a question by typing it into the Q&A button. You'll find that at the bottom of your Zoom window. So if you have questions, go ahead and put them there. So I just wanted to briefly say a few things about my research on the criminalization of pregnancy. We don't need to wait and ask what'll happen with criminalization when Roe goes away, because it's already happening. It's been happening. It's been happening since Roe, really, at a state-by-state level. So the book that I'm working on right now builds out from my dissertation research. And I analyzed at that time around 800 arrests from 3 states, South Carolina, Alabama, and Tennessee. Arrests where, but for the fact of the pregnancy, there would be no arrest. There would be no crime. Every state but Vermont and Delaware has done this. And California does it too, right? We've just had someone's conviction overturned after she spent 4 years incarcerated because she had a miscarriage. So, even in these sort of liberal meccas like California, this is still something that's happening. And there is legislation in California right now going through the process that would try to stop this from happening. We'll see how effective that is. One of the things that I have seen is that a lot of the time these arrests happen even in the presence of legislation that says you cannot charge a pregnant person with a crime against their own pregnancy. They do it anyway. And that's mostly because they are targeting the most marginalized people. They are targeting people of color and low income people primarily, folks who probably don't have money for a private attorney, folks who don't necessarily have a robust knowledge of the law, who are not necessarily able to fight these unlawful prosecutions, right? So what kinds of things do people get arrested for? I know I mentioned a few things when we were opening it up, things that even with the protections of Roe v. Wade, folks have gotten arrested for include, but are not limited to, having a miscarriage or stillbirth, using drugs based on the presence of a single positive drug test. Now, using drugs is generally not a prosecutable offense, right? Having drugs, making drugs, selling drugs, driving a car while you're under the influence of drugs, right? These are the things. A positive drug test, not so much. It's sort of considered a form of self-incrimination, right? Unless you're pregnant. But there are also people who have been arrested for using legal substances, cigarettes, alcohol, and even their own prescription medications, many of which you're not supposed to use during pregnancy, right? Attempting suicide, people have been arrested for this. Again, not a crime. We recognized it wasn't useful to make suicide a crime, right? It's not deterrent. If you're already in a place where you are willing to end your life, the deterrent effect of making it a crime, what are we doing here, right? And it also makes people less likely to seek help, medical help, if they've survived an attempt, right? We've also seen arrests for things like being beaten up while you are pregnant, being hit by a car while you are pregnant, being shot in the stomach while you are pregnant, because it has been determined that you were asking for it. We've also seen people arrested for things like eating poppy seed cake and bagels when they have a false positive drug test for opioids. People have been arrested for falling down the stairs. People have been arrested for running while pregnant. Any runner, I mean, running's bad enough, like, right? Running's already terrible. You're gonna lock some people up for it. Disobeying a doctor's orders, something that non-pregnant people who are adults of sound mind have a fundamental right to do. Not consenting to involuntary cesarean section, right? Essentially being cut open against your will and then charged with crimes after the fact. And even, and maybe most relevance to this conversation, for self-managing abortion or for being accused of self-managing abortion. The list of things you're not supposed to do when you are pregnant is nearly endless, right? And we also know that pregnancy outcomes are frequently completely out of our own control. A million things go into a pregnancy outcome, right? And so to charge people essentially with forms of child abuse because they have a negative pregnancy outcome, that is something that we've also seen. Now, we know that when abortion is illegal, people will still try to have abortions. Some people will be forced to give birth. Some people will be able to travel to states to get abortion care. And some people will be left on their own. We are in a different landscape than we were before Roe v. Wade, right? It's why a lot of people are saying, don't use that clothes hanger imagery anymore. Please don't try to end your pregnancy using a clothes hanger. There are other better ways to illegally end your pregnancy, right? We have pills now. Right. And so this is probably going to be the way that many people attempt to end their pregnancies. Misoprostol it's part of the prescription cocktail of medications we use to end pregnancies. It is also an ulcer medication that you can get at any doctor or veterinary office, right? It's also like readily available over the counter. So people will probably be getting miso. And so, hopefully we will have fewer self-managed abortion-related injuries and deaths. However, we will have abortion-related pregnancies and deaths. Not everyone will be able to access these pills. Not everybody knows that they exist, right? And so that's a little bit different. How are people detected? When we talk about the criminalization of pregnancy, how do people get caught? What brings them into the criminal justice system, or what puts them in contact with the criminal justice system? To me, the scary thing is that most of the time it is the healthcare providers that are either choosing to or are being forced to play detective, do non-consented to searches on their patients and reporting any information that could be seen as, potentially harmful to a pregnancy to law enforcement or to social services. If the fetus is a person, you have no right to medical privacy. Right? They are required to override your the confidentiality of your medical information, right? If the fetus is a person and you're putting it in danger, they're required to notify somebody of this. This is huge. This means if you need medical care, it might not be safe for you to seek that care from healthcare providers. People will die because of this. Children will be left motherless because of this. Things that could be treated by antibiotics, right? A simple fix will result in sepsis and death because of this. This is something that we've already seen it, right? And we are expecting more of this. People are also turned in by abusive partners, family members, or even friends. Right now, we've also got like the internet. this is another way that this will be different, right, than in the pre-Roe days. And so the use of electronic data as evidence against people will come into play. Certainly it already has. If you are someone who uses a period tracker app on your phone, I want you to look into the privacy settings of that. Even emails, texts, internet searches, your search history, even your location data, all of these things could be used as evidence against you if you have actually ended your pregnancy, or if you were being accused of ending your pregnancy. And what do the punishments look like? There's a big range of things, and it kind of depends on what action is being criminalized. People lose custody of their children. People are put into court-mandated, super inadequate, very problematic drug treatment programs. And people also are given long prison sentences. These are frequently felony offenses, right? So there was a case in Indiana where a woman was given it was a 41-year sentence. She was for 2 different charges. She was allowed to serve them concurrently, but we're talking about large portions of your life behind bars, potentially, for things like having a miscarriage. So, it doesn't look good, right? We can take lessons from this, right? That this is the kind of stuff that we can expect to happen in a post-Roe landscape. It is only going to become more widespread, and we are only going to see more arrest numbers. So that is what I have to share with you. We do have some questions in the Q&A, so I'm going to start reading through some of these, and then if any of our panelists would like to jump in and answer them, go ahead.
Grace, can I add one thing before you move into the questions?
Do it.
One of the things that we have not talked about yet today is that the United States is one of the most dangerous places to be pregnant in this world. That we have one of the highest rates of maternal morbidity and mortality of any country, right? We are a mess in this country, basically. And so the other thing to think about in terms of risk of both serious complications and death is simply staying pregnant. And the risk of dying from pregnancy complications is 2 to 3 times higher for Black women. And the really, really weird statistic is that for college-educated Black women, the risk of dying in pregnancy is 5 times higher than it is for white women. It's extraordinary. Don't ask me why that is, because they haven't quite parsed it out yet. But the fact that there are people who will be forced to stay pregnant, standing alone, right? Not because they're trying to get illegal abortions or anything like that. Simply being forced to stay pregnant will lead to people dying.
Yeah, I believe that the estimate is that the maternal mortality rate will rise about 21% as a result of the Dobbs case. And that is in a country where it is already rising and where it is already like hugely disproportionately high for Black women. Yes, thank you for saying that out loud. It needs to be said. So thank you. All right, so some questions. We have one from Matthew Moore. He asks, he says, the draft definitely adopts maximalist language that raises red flags about the threat to all substantive due process jurisprudence, all the way back to Loving versus Virginia. There has been some discussion about whether the final draft of this opinion will be toned down to be slightly less extreme. I'm wondering what everyone's view on that is. What do you think?
Sorry, I was muted there. I think it won't be toned down, and if it is toned down, only in very minor ways, because the heart of this opinion is to say that the rights of privacy that we got in Roe, the rights of equality that have been recognized since Roe in this arena, are not part of the Constitution, both explicitly, as Kim so eloquently described, but also because in their view, the 14th Amendment is very narrow. The meaning of liberty, really, in my view, I think the only, I don't see where they will find a liberty interest. I think they believe the Due Process Clause is only procedural. That is, it gives you a right to a hearing in the event that your property or you are jailed, property is taken away and you are jailed. So it's a very circumscribed view of the 14th Amendment and substantive due process that goes back well before Loving versus Virginia. It started in the 1920s with the cases involving the right to make educational decisions about your children. All of that history, in this case, 10 decades or more, has recognized a substantive right that flows from both liberty and equality in the 14th Amendment. And this court, these 5 justices, don't think that's the case. And if you look at earlier decisions, going back to Chief Justice Rehnquist, but more recently around kind of the originalists on the court, they all come back to this notion that the 14th Amendment is very narrow and is procedural only. And so when people say, well, you're making it up that they're going to go beyond abortion, I don't think that's the case. I think this court is very committed to undermining any notion of liberty as protective of substantive rights. And let me just say, I agree that it won't be a frontal assault at first. That is, the right to contraception. No, very few states are going to ban all contraception. But we are going to see a whole range of both regulation of contraception and, more importantly, certain forms of contraception. The IUD and the pill and the morning after pill, those 3 being the first that are likely to be attacked. We've already seen huge attacks on trans kids. Okay, that's going to expand. Because if you don't have a right to decide your sexuality and make decisions about your body, then it's fair game to attack them. And I think, and this is the part that I think is really interesting, this whole notion that we're seeing in the states right now of banning books about sexuality and reproduction, banning books about gender equality, banning books about any family formation that is not heterosexual white people being married, is extraordinarily disturbing. And I think this court is likely to say state school boards have the right to do that. And that, in my view, is not only just an infringement on abortion and reproductive justice and the notion of making important decisions about your life, but what information all of us are entitled to obtain in this country. And it boggles my mind that we are back to a day in which books are banned and sexuality is questioned and family decision-making and family formation is questioned. And, I'm a lesbian woman who had kids in the 1980s. Okay. That was early in those days to be able to make decisions about how I wanted my family to be formed. My kids are now in their mid-30s. And they, are the first to say it is the rights guaranteed in Roe, the rights guaranteed in Casey that made that possible. And it seems to me when we are coming back to a day when the decisions about whether you have children, with whom you have children, how you have children, are questionable, when they can be regulated by politicians and judges as opposed to individuals. We are very, very close to an authoritarian state, and that is extremely disturbing.
And I want to just add a little bit to that incredibly frightening layout that Kitty just gave us. Oftentimes when we have these conversations, people say, oh, you're being hysterical, right? Because women are always hysterical and you're, just running down through this parade of horribles. But I think the other thing that we have to really think about here is the way religion is going to play into this as well. This Supreme Court has not seen a religious right that they are not willing to uphold. Right. And if you think about a case like Hobby Lobby, which was one of the Affordable Care Act cases, where you had Hobby Lobby saying, we don't want to be forced to pay for women to get IUDs. Yes, Christian religious right. Exactly. We don't want to have to pay for people to get IUDs because we think right? Because the way we're going to define what abortion is, we think that anything that has the risk of potentially keeping a fertilized egg from implanting in a uterus is an abortion. So what we're going to see is this sort of, one, this willingness to pretend like medicine and science don't exist and you can just make up your own definitions of things. And two, this incredible elevation of religious liberty, specifically for people who are Christian and fundamentalist communities. And all of that is going to come together in a way that I think is really, really dangerous.
Edie.
Hello. I just wanted to show off my shirt here today. Thank you all for coming. And also ask a little bit about the strategy here. It doesn't seem to me Alito would have been a rights holder at the time, right? Neither Miss Amy. And so if that is the case, how, and I'm sorry, but also Miss Ginny and Clarence Thomas.
Yeah.
Right. So many of the
an interracial couple, y'all.
Yeah, no, sorry, yes, the Loving versus Virginia question about interracial marriages, right? I don't understand. Perhaps it is because I have cognitive dissonance, and apparently that is not shared by many of my family and friends who live in the Midwest, right? What is the strategy for professors trying to teach young people about the law and whether facts matter? And even if facts don't matter, if the interpretive canon of originalism is such that it ignores the fact that maybe abortion was not mentioned in the Constitution because there were no women mentioned, but also because it was common and not a big deal. Like, if history itself is not a basis, then what is our strategy, whether cynics or true believers, right, in the power of the court to kind of right itself after periods of injustice? And I just don't know what to tell my students anymore. And so kind of how do we move forward from this moment? And thank you all for making this happen. I hope you'll join us again in the fall when we resume this conversation.
Yes. And Edie is one of our Human Rights Institute folks, and she is on Troll Patrol for this panel. So thanks, Edie.
I'm here for the stench on the bench also. So looking forward to your correctives and what we do with our students who don't, in part, and I think Kitty raised her hand, but they don't have the victory myth. They don't understand American exception. Like, so part of the problem, I think, is we had good faith in some of the things that were being said. We're like, okay, we'll take it. You're on your originalist tour of your selected history. How do you teach this to students who don't understand the role of the court and why it has been had such deference given to it?
So let me see if I can take this on a little bit, which is I often talk to groups of lawyers who tell me all the time, well, did you try this argument or did you try that argument? And, maybe it should be based on the religion clause or lots and lots of advice about how we could have done this better in order to win. And my answer to them is the same as my answer to you, which is this isn't about logic. This isn't about good arguments. This isn't about a proper interpretation of the Constitution. This is about political power. And some people who want to have it in our society and take it away from everyone else. This is about Mitch McConnell being able to stop President Obama's nomination to the court and to rush through Amy Coney Barrett's nomination to the court, and the ability of states to pass these restrictive laws is because the Republicans have a majority in these states. And so the only answer to what seems like an extraordinarily depressing conversation and one that has very limited logic and good standing is stop thinking about this as rational and begin to think about it as the power to take action against the rest of us. Can a minority in this country exercise their power to take away the rights of all of us? And the answer to date is yes, and it will continue to be yes until we stand up and say no more. And we have to do that state by state, district by district, and really focus on those places which are controlled by the Republicans and electing people. Now, the good news is this is possible to do. Why? Because now latest polls are showing close to 80% of this country believe that the decision around abortion ought to be made between a woman and her doctor. Over 60% support the rights in Roe and Casey and do not like what the court has done. We have a majority. We don't have to convince anybody who's against us. We have the majority. But what we don't have is political activism. We don't have the majority voting, working in campaigns, giving to campaigns, doing all the things that are critical to win small races. And let me just add one more quick thing, which is this is doable because most state legislative races are decided by very, very, very small margins. Okay. In Pennsylvania, I counted in 2020, there were 16 seats that were more than enough to flip the legislature from red to blue that were decided by under 1,500 votes. Okay. That's like 3 votes per precinct in some of these districts. And so it's really, really important for us to begin to do that hard work and say, let's forget about logic, let's forget about good sense, and let's work to taking back political power.
I love that answer. Anybody else want to add to that?
I just wanted to say quickly too that part of that question was, what do professors do and how we relate to our students? And I think that's a really good one. So I'm a professor at Penn State, and Penn State is in the middle of Pennsylvania, in the middle of rural Pennsylvania. And our abortion clinic closed in 2007. The closest place for a student who goes to Penn State to get an abortion is about an hour and 45 minutes away. To think of the need at Penn State, which is a very large university, and that our closest clinic is pretty much inaccessible to folks without transportation. We don't have trains, and we have some buses, but it's very difficult to do this, is worth noting because while I'm currently in Portland, Oregon, where we have a law in the books here at the state to protect access to abortion, a lot of states have been living in this reality for a long time. If you live outside of Philadelphia and Pittsburgh, even in a state like Pennsylvania, as Kitty, you were just talking about, this has been the reality for a while. So I also want to say too, is that there's a real precarious situation going on with a lot of educators as well. As we saw in Florida, as we see across the country, it is not always safe for educators to be on the front lines to actually advocate for the education of these students, both in terms of precarious labor, such as being an adjunct, all the way up to actually having limits on what you can teach and the political repercussions of that. I think that this is we very necessarily have a multi-pronged strategy here, which is starting at the local, thinking about how we can, for example, in a place like State College, Pennsylvania, where we have 3 pregnancy crisis centers and 0 abortion clinics, thinking about how we might change our local communities and really increase access for a lot of the population that's been living like this for a long time. So I just wanted to add that as well.
Thank you.
And I'll give my rah-rah speech as well. I am not a glass half full person. I'm a glass half empty person. And so I really have to build myself up in these times. And there are 3 things really. One is thinking about my 14-year-old and my 16-year-old who are as outraged by everything that is happening here as I am. And there are lots of us out there who are raising really lovely feminist children who are going to go out and rattle the cages. That's really critical. 2, I think a lot about, the history of Black folks in this country, right? I'm the dean of a law school. Who would have thunk it? right? I mean, so there's an enormous amount, it's hard to sometimes see it in the moment, but there has been an enormous amount of change in this country over time, and it is possible, it is doable. And then the last thing that I say to myself all the time is that so much of the backlash that we're seeing now is what it looks like when people with power get afraid of losing it. And that's what's happening, right? They are watching the demographics in this country shift, and they are watching themselves losing the ability to demand that we live in this country the way that they want us to live in this country. And so if you think about it in those terms, right, then all this is about really is a bunch of really scared people who don't want us to take their stuff. And they don't have a right to that stuff, right? And so we're the ones who are in a position to really continue to shift that timeline. And it takes a long time, and we're not all going to be here to see it happen, but we're all a part of that puzzle that's moving us in the right direction.
Amazing. And another question, this one from Tanya Bakru. She says, this panel has been incredible. Thanks. Thank you so much. You're welcome. Can you please speak to the implications of these changes in law to adoption and foster care, interracial adoption, adoption by LGBTQ people, single people? I'm thinking specifically about Alito's reference to the domestic supply of infants. It's freakishly dystopian. Yeah, it is freakishly dystopian. Right. So we already know it's true today with abortion legality, that annually about 20,000 kids age out of the foster care system, right? And that these kids disproportionately are not white kids, and these kids disproportionately have disabilities, right? And that when they age out of foster care, they are just dumped, right, and left to their own devices. And so, yes, the idea, especially in the oral arguments of this case, it was dictated that, don't worry about it. You can just drop your baby off at one of those baby boxes. It's like dropping your old movies off at Blockbuster. It's like not even a big deal, right? As though 9 months of pregnancy and giving birth is not a freaking big deal. And as though the fact that there's now like a human in the world is not a big deal either. So thank you so much for asking this question. I know Tanya's writing an incredible book right now about adoption. And so, yeah, what do y'all have to say about this?
I'm gonna put on my assisted reproduction hat for a second, because I think that this is one of the reasons why the appeal of embryo adoption is going to really balloon. Because what a lot of people want when they are looking to adopt is an infant, hopefully a newborn, right? If you can make that happen. And they want to have a pretty strong sense of sort of what the environment was, right? While that baby was being gestated. And so when you think about the thousands and thousands of embryos in this country that are not being used, that is just that is a domestic supply, right? And so, if we do have states that say, listen, and Louisiana is basically there already, right? It's just one more step for them to really, cross that line. States that say, abandoning your embryos is the same as dropping a newborn off at a firehouse. And if you drop that newborn off, we would find other people to raise that child. Why shouldn't we do the same thing with embryos? Which is monstrous to think about, and yet totally possible.
Years ago, I had a case, you all probably remember it. There was a judge in Tennessee, I think it was Tennessee, who ordered the implantation of fertilized embryos in a woman who wanted to give birth, because leaving them in the clinic in opposition to the father's decision to who the man did not want to have kids. And the judge said, well, the woman wanted kids, and I'm going to require that she get pregnant with these embryos because, of course, I have the power to do that. We represented the man, and that's exactly the dystopia you're talking about, and I see it happening again and again. And this was in the 1980s, so it's not like this hasn't happened, and it is much more likely to happen now.
And I should say Arizona already has a law that says when there is a dispute about embryos, that they should go to the person who is most likely to be able to bring them to fruition.
I mean, the only thing I want to add to all of this, which is again more assisted reproduction stuff, is that, you know, this sort of adoption of embryos is a really interesting story. There's a complete financial component of freezing and storing embryos kind of indefinitely. We also have decades old embryos because IVF has now been around for 30 some years at this point. So I think there are like real practical questions, as well as I said before, clinics that accidentally or unintentionally destroy embryos, what happens there. The other thing I just wanted to add in terms of this question about adoption is the religious part of this adoption. And I think it intersects, Kim, with what you were saying about the role of religion in contraception. I think it also intersects with the ability of adoption agencies to make decisions around who can and can't adopt. We used to see this back in the regulation of ART way back in the day in the 90s, where some clinics would not actually allow single or LGBTQIA plus folks to use infertility services. So that also might be a point of intersection as well.
Yeah, I mean, I will say, like, you know, women aren't in the Constitution, queer people aren't in the Constitution, single people aren't in the Constitution, and parenthood is not addressed in the Constitution. So the implications of this is that like states can just do whatever they want, right? And that's already true in some ways, right? The Supreme Court is allowing, especially religiously affiliated adoption agencies to be discriminatory and kind of whatever they want. So I think we can only expect more of this coming down the line. The next question relates to the issue of fetal personhood. I'm concerned that many of us in more progressive states may be too complacent about the implications of the Dobbs decision because they feel that being in California or New York or Massachusetts, et cetera, will shield them from its impact. However, as Erin discussed, attempts to gain recognition of fetal due process rights are gaining traction. And it seems clear that the end game is to get a SCOTUS ruling that would effectively prohibit reproductive justice in all 50 states. In the view of all of our panelists, how likely is this current court to be sympathetic to this?
So I hate to keep going first, but I'm going to jump in on that, which is I don't think this court is going to say it's mandated to prohibit abortion in all 50 states. But I do think Congress, if they have the power to do so, will pass just such a statute. A number of members have been talking about it in the last 2 weeks. Mitch McConnell said we're not going to rule it out. Then all of a sudden he got slammed for that, so he's now taking a step back from that position. But again, if this is about political power, and the goal of the anti-abortion movement is to prohibit abortion in all 50 states, the easiest way to do that is to pass a federal statute that does so. And I think once they have the votes and the presidency, they will do that. It is a fear that even if we can overcome the filibuster or change the filibuster and pass a federal law that protects abortion rights, the minute there are votes on the other side in sufficient numbers, that will be taken away. And so, you know, in our book, we spend a lot of time talking about a constitutional amendment that at some point we will need. That may be a 50-year goal. We call it a gender equity amendment. It's kind of a broader ERA, but it's not just around reproduction. It's not just about women's equality. It's about all kinds of issues involving LGBTQ plus people and a variety of other rights that have been protected, as we've been talking about here, through Roe and Casey and a variety of other decisions of this court. So, yeah, in the long term, constitutional amendment. But again, this is going to play out in the federal legislature as soon as there's enough votes on either side.
And I want to reinforce. I can't remember who said it. It was probably Kitty early on in our discussion. The importance of local and state politics, right? Particularly because states have constitutions too. And some of those constitutions are much lovelier than the federal constitution. And so in some of those states where, you know, people like me in New Jersey are feeling a little bit complacent. One, it's because we have a really good state constitution. And two, it's because our legislature already passed a Reproductive Freedom Act that codifies the right to abortion on a state level. And that, as far as I'm concerned, that's just a foundation, and our job is now to build on that. But it is a real sign that probably for too long, a lot of us have ignored what is going on the state level. We've ignored state judges, many of whom are elected, right? And so there's power there that we have been leaving on the table that we should really take back.
All right. Here's another, probably just maybe a question or two, depending on how long our answers are. Has there been any talk about states wanting to look through mail, coming in from out of state to look for abortion pills? Yes, right. We've seen a lot of legislation trying to, prevent that from happening. Right. The FDA approved the use of telemedicine for abortion pills during the pandemic. Yeah. It is safe. It is safe to talk to your doctor on the phone or via Zoom and then do your abortion at home with pills. It's safe to do. But in states where they don't want abortion pills to be, a thing, I think it's certainly possible that they'll be searching mail. We've already had cases like this. So there was a case, I believe this one was in central Pennsylvania a few years ago, where a mom who was a nurse ordered illegally through the mail abortion pills for her daughter, and was subsequently arrested and I believe sentenced to some jail time for that. Right. So it's already happening. It will be happening. They will search mail. Right. And so this is one of the ways that people could potentially get caught doing medically safe, but legally risky self-managed abortion.
But let me just say this about that, which is women are very crafty. Women have gotten abortions even when they were illegal for centuries. Okay. And so it seems to me it's really important for us to, I'm not going to advocate illegal activity. Okay, I can't do that. I'm a lawyer. I'm just not going to do that. But I will say that in states where the abortion pill is legal, we need to, what I think of as flood the market. We need to make sure that it is really easily available to people who are both pregnant and not pregnant. You all ought to be able to have the abortion pill in your medicine cabinet for use going forward.
Before you need it.
Before you need it. And every college campus ought to be giving out this drug in the same way that California now mandates. You're the only state in the country that now mandates universities, health centers to have the abortion pill available. But all of you students who could have it in your medicine cabinet, that's important because you may have friends who live in states that don't have it available. And it's easy if you live in, a contiguous state to go to that post office box right across the state line, et cetera. There's lots of ways around the law that I'm not advocating for, but that crafty women will find available. And the most important is aid access in Europe. A doctor who does prescribe the pill by telephone, really good success. Years ago in Ireland, she suggested that we bring boats off the coast of Ireland where abortion was banned and provide abortions in international waters. My dream is to take some of those yachts from the Russians that are being confiscated and just, stick them off the coast of Alabama and Mississippi and international waters and provide abortions. Or, there's all kinds of creative things we can think of to do.
And in terms of the mail, I know that there's also some discussion about which post service you use, right? So if you use USPS, maybe a little bit easier to search your mail than if you use, for example, FedEx or UPS, right? So even within, delivery of stuff through mail, there's some finagling and maneuvering that can be done, right? Oops. I think we have time just for one more question. And we'll go with Brittany Ortiz, who asks, to what extent do you think this ruling damages the legitimacy of the Supreme Court? Do you think that packing the court is a possible solution to future rulings on fundamental rights?
The only reason why I would say I don't think it damages the Supreme Court is the deep cynicism that I have had about the Supreme Court for a really long time. I think that there is now a broader understanding, right, over the last few years of one, how important the court is and courts in general are, and two, of how wildly and deeply political the US Supreme Court is. I think people just weren't paying as much attention, right? If you're a lawyer, you're sort of invested in this stuff, and people weren't paying as much attention. And so, I really think, I love the question that Justice Sotomayor asked at the Dobbs, oral argument, where she basically said, can the Supreme Court survive the stench of what is happening here, like the raw politics of what is happening here? And of course, it will survive. But to the extent that this sort of broader understanding of how deeply flawed the court is, and the structure of the court, and how wildly political it is, has been, but certainly how wildly political it is now, we may see some types of reforms, because 9 justices, that's not in the Constitution, right? I mean, so lifetime terms. We may see some differences. I don't think that packing the court is a particularly good idea, right? I do think not letting them sit for forever and 50 days might be a good idea. So we'll see what happens.
So my view is slightly different, which is I do think it's really problematic for our nation when the institutional integrity of the court, or when the Supreme Court is viewed in such a political way. And that's a bad thing going forward. We have survived lots of bad rulings, but I don't think we can easily survive the perception that the court is such a political animal that's willing to throw out centuries of law that so many Americans have relied upon. And this is just the beginning of that. But I also think that we don't have the political power to make change right now. I mean, if we can't pass a bill to legalize abortion, we're not going to pass a bill to change the makeup of the court. So let's focus on what we can do as opposed to what we might do. Once we have political power, there's a whole lot of things we can do in this arena and many others, but we need to get there first.
Any other thoughts, contributions? We've got about 5 minutes left. Here, Professor Kinney's asked a question: who leaked the opinion, and does it matter? Right? I know there's been a lot of speculation about this. Is it a pro-abortion rights clerk who is risking their career to be like, y'all, they're gonna do it, an extra month or a few weeks to plan, or something like that? Or is it an anti-abortion zealot thinking, I'm gonna take a little bit of the steam pressure out of the inevitable outrage of when this decision is formally released, or some other thing? What do y'all think?
Well, I'm going to go with
Oh, go ahead, Kitty.
As I say, I'm going to go with Nina Totenberg, who believes it came from the right in an effort to solidify this opinion. There's no upside for the left leaking this.
Yeah.
I mean, if you're going to leak an opinion, you want to leak the dissents. You don't want to leak the majority. It may take the steam out of it, but really, this is the moment that the light bulbs are going off in the country. So the steam has happened. I think it's the right, but I also think it's irrelevant. It's not the first time it has happened. I don't know if most people know that Roe versus Wade itself was leaked. The difference was it wasn't published because Time Magazine agreed to hold the information until the court released the decision. But in today's media climate, that wasn't going to happen. But I don't think anyone on the left would risk their legal career and their livelihood for a couple of weeks worth of change in the news.
All right. So we've just got a few minutes left. So I wanted to give kind of a closing and to thank some people and to announce some things. So thank you so much to each of our panelists. Like, y'all, these books are a big deal. And we were able to like scrabble this thing together so quickly at the end of the semester when everybody is tired and stuck in grading jail. So like, thank you so much for being here. Thank you to the Human Rights Institute for helping me figure out how to do a webinar. Because it's my first time. And thank you so much to everybody on who came to watch this panel, for taking time out of your lives to sit in on this conversation. It is not a question of if anymore. This is happening, and it is just the beginning. We need to be prepared to take care of one another and to protect one another. The good news is that we have been prepared for this moment. People who care about reproductive justice have been anticipating this moment for a long time, and we do have strategies in place to respond. If you want to get involved, seek out these pre-existing organizations, especially your local organizations. Get involved in practical support for patients seeking abortion. Donate to independent abortion clinics and abortion funds. Learn internet security, okay? I also wanted to mention that there is a protest happening on campus on Monday, May 16th at noon. We're going to meet by the Olympic Black Power statue, so please be there. Remember, the law is pretend. People made it up. So are our legal institutions. And this means that we can remake them and we can unmake them. We can build a more just world, but we have to do it. They say that the arc of the moral universe is long, but it bends towards justice. Maybe, but we have to do the bending. So get ready to get your hands dirty. Thanks so much.